Artificial intelligence generated this video. Any opinions stated are that of AI. In this video, we will explain a 42 U.S.C. Section 1983 civil rights action filed in the Superior Court of King County, Washington. We will walk through the complaint filed by Miriam Zayas, a pro se plaintiff, explaining each section of the lawsuit, why it matters, and how to structure a civil rights complaint against a municipality when you are representing yourself. This lawsuit was dismissed by the Seattle District Court Clerk and Jamia McCrae and was never seen by an actual judge. On May 3, 2024, Issaquah Police Department officers removed a child from her daycare without legal grounds, violating constitutional rights. Miriam Zayas claims this act breached her First and 14th Amendment rights. This civil rights lawsuit, under 42 U.S.C. Section 1983, addresses an unlawful child removal, familial association, due process, equal protection, and municipal liability under the Monell Doctrine. Establishing parties and jurisdiction is crucial in civil complaints. Miriam Zayas, a resident of Issaquah, Washington, is the plaintiff. The defendant is the City of Issaquah, responsible for the Issaquah Police Department. Federal jurisdiction is based on 28 U.S.C. Sections 1331 and 1343, and Article 3 of the United States Constitution, with venue in King County. Every civil complaint must begin by stating who the parties are and why the court has authority to hear the case. For pro se litigants, this section is not optional. Courts can dismiss a case at the threshold if jurisdiction is not properly established. When filing a lawsuit against a city, clearly state the legal authority for the court's jurisdiction. For a Section 1983 claim, rely on 28 U.S.C. Section 1331 and Section 1343, 42 U.S.C. Section 1983, and Article 3 of the United States Constitution. Pro se litigants benefit from a less stringent standard, but jurisdiction must be explicit. Key rule for pro se litigants: courts are required to hold your pleadings to a less stringent standard than those drafted by attorneys. Eldridge v. Block, 832 F2D 1132, 9th Circuit, 1987. This means missing legal terminology will not automatically doom your case, but jurisdiction must still be clearly stated. Section 1983 is crucial for holding officials accountable for constitutional violations. It requires proving the defendant acted under state law and deprived a constitutional right. The First Amendment protects familial association, while the 14th Amendment ensures due process and equal protection, safeguarding the parent-child bond from unwarranted state interference. Section 1983 holds government actors accountable for rights violations under state authority. Acting under color of law means using state power, as IPD officers did at the daycare. Pro se filers must allege a government actor used state authority to violate constitutional rights, like First and 14th Amendments. Courts interpret complaints liberally. Acting under color of law means the government actor used or misused the power granted by the state. When IPD officers arrived at daycare, in uniform with badge and authority, they were acting under color of state law, regardless of whether their actions were ultimately lawful. The factual allegations highlight a pattern of unequal treatment by the police department. On May 3, 2024, Issaquah Police Department unlawfully removed toddler AZ from daycare without a valid custody order or visible injuries. This incident, alongside Issaquah Police Department's prior refusal to arrest the plaintiff's son, underscores the wrongful actions taken without probable cause or proper authority. Video evidence shows IPD officers visiting the plaintiff's home without a warrant, indicating a pattern of misconduct. When the plaintiff reported her son for assault, IPD refused to act without visible injuries, unlike their removal of AZ without cause. This unequal treatment supports an equal protection claim. Plaintiff retains video recordings of IPD officers coming to her home regarding CPS matters without a warrant or probable cause. This establishes a pattern of conduct and provides tangible evidence of the officers acting under color of law. When plaintiff called IPD to report her son assaulting her, officers refused to arrest him, requiring visible blood or bruising as a condition. This same standard was not applied when removing AZ. The child showed no blood or marks, yet was removed anyway. This disparity supports an equal protection claim. The removal order was legally defective. Revised Code of Washington 13.34.050 and Revised Code of Washington 26.44.050 allow officers to take the child into custody, not from the parent's custody. AZ was not abandoned, and no court order was agreed upon by the parent. In Section 1983 cases, actions without statutory authority are unconstitutional. Cite specific statutes to highlight discrepancies. The Rooker-Feldman doctrine is often misapplied. It only bars cases where state court losers complain about injuries from state court judgments. Here, the injuries stem from police conduct, not a court judgment. Thus, this doctrine does not apply, as clarified in Bear v. Campbell. Defendants may attempt to use the Rooker-Feldman doctrine to argue that a federal or state court cannot review what happened in prior state proceedings. Plaintiff anticipates and rejects this argument. The injuries alleged here, the unlawful physical removal of a child by police, were caused by officer conduct, not by any state court judgment. The doctrine is narrow and does not shield unconstitutional police action. Under the Monell Doctrine, municipalities like the city of Issaquah can be held liable under Section 1983 for constitutional violations stemming from official policies, customs, or practices. This includes express policies, widespread customs, and actions by final policymakers. Municipalities cannot claim qualified immunity, making them accountable for institutional misconduct. An official written policy that, when enforced, causes a constitutional deprivation. A practice so widespread and entrenched that it carries the force of law, even without being written down. IPD's use of dependency petition statutes to remove children without explicit statutory authority qualifies. A constitutional injury caused by a person with final policy-making authority, including judicial ratification of unconstitutional removals. Qualified immunity protects officials from civil damages unless the law was clearly established and a reasonable official would believe their actions lawful. However, the right of parents to live with their children without unwarranted interference is well established, negating qualified immunity. The city cannot claim this immunity due to habitual illegal enforcement. The First Amendment safeguards the intimate association between parent and child, prohibiting unjustified separation. The 14th Amendment ensures due process, requiring notice, hearing, and evidence before separation, barring emergencies. Additionally, equal protection is violated when a parent is discriminated against without rational basis, as shown by audio-video evidence. These constitutional rights are crucial in protecting family integrity. The First Amendment protects familial association, the fundamental bond between parent and child. Removing a child from her mother severs this protected relationship without legal justification. Boehm v. Luzerne County CYS, 172 F sub 2D 575 MD PA 2001. The 14th Amendment details the right to family integrity is a liberty interest. The state may not separate a parent and child without due process, notice, hearing, and evidence, except in a genuine emergency. No emergency existed here. Meyer v. Nebraska, 1923. Plaintiff has audio-video evidence showing she was treated differently than similarly situated parents of other races and backgrounds, without rational basis. Intentional arbitrary discrimination by state actors violates equal protection. Kuiter v. Parma City School District, Ohio 2020. Supervisors can be held liable in a Section 1983 case if they participated in, directed, or knew of a violation and failed to stop it. Liability attaches with personal involvement or a causal connection to the violation. Naming supervisors strengthens Monell claims by showing institutional decision-making, not isolated mistakes. Under Section 1983, plaintiffs can seek compensatory damages for mental anguish, humiliation, and out-of-pocket losses, as established in Carey v. Piffus. Injunctive relief and pro se cost recovery are also available. The plaintiff requests an injunction against future violations, compensatory damages, and litigation cost recovery. Municipalities are liable for damages without qualified immunity. Plaintiff seeks A. An injunction prohibiting future constitutional violations against her. B. Compensatory damages including mental anguish, humiliation, impairment of reputation, and out-of-pocket losses. And C. Recovery of actual litigation costs as a pro se litigant. Burt v. Hennessy, 929 F2D 457, 9th Sir, 1991. Municipalities are subject to compensatory damages and have no qualified immunity shield. Owen v. City of Independence, 445 U.S. 622, 1980. To file a Section 1983 complaint as a pro se litigant, establish jurisdiction by identifying parties and court authority. Present facts in numbered paragraphs with specifics like dates and names. Cite constitutional violations and relevant cases. Address potential defenses like qualified immunity. Clearly state the relief sought, including injunctive relief and damages. Be specific. Ask for injunctive relief, stop the illegal conduct, compensatory damages, money for your losses, and recovery of litigation costs. Sign under penalty of perjury and include your contact information. If you expect the defendant to raise Rooker-Feldman, qualified immunity, or Monell pleading burdens, address them preemptively in your complaint. Show why they do not apply to your facts. Zayas v. City of Issaquah was dismissed by the court clerk and was never read by an actual judge. Jamia McCrae is best friends with the Seattle District Court clerk, and they have dismissed many of this mother's lawsuits. Remember, if you did not hear the judge dismiss it, then they probably did not dismiss it.
This is Judge Adrienne Thomas McCoy. She is afraid of African American people. She will do whatever they tell her to do. She works for the Superior Court of King County in Seattle, Washington, and she's been a judge for a few years, and she was never a prosecutor. That's what it says on her bio. That is not true. She was never a prosecutor, okay? They say a lot of lies on these judges' bios, but they just pick the person who's willing to do the job, okay? They have to do what they say, you know, and they can't go against what they say, okay? And they rarely do, okay? Sometimes, every now and then, but she enjoys allowing these African American state officials to torture Caucasian women every single day in her courtroom. She lets it happen. She watches it happen. She knows they're being unfair, and she allows it, and she rules in their favor all the time, okay? Especially when they're, you know, have the Caucasian mother has African American children. She will destroy their entire family, okay? Yes, she will. She will do anything that CPS tells her to do, okay? She is a complete pushover, and she was only hired because her eyes are blue, and she doesn't know that she probably knows now, but she's a blue-eyed robot. That means she was hired to be sued, and basically they want people to hate these judges, you know, because they can't do it themselves. They would never do it themselves, okay? So they send in these judges that are pushovers that, you know, have blue eyes themselves to target and terrorize people that also have blue or green eyes, okay? And she probably doesn't even know, or didn't know before, that all the parents whose rights she terminated didn't have brown eyes, She probably didn't know that. Now she knows, and she's still doing it. She still lets them do what they want. You know, she destroys families of biracial children all the time, every single day in that courthouse. Okay, and she does it because they tell her to. Because Natalie Green tells her to. Because Jamia McRae tells her to. Because Sylvia Howard tells her to. And she knows who all these people are. Even though she's a judge and really shouldn't because they're supervisors in CPS, she still does know who they are. Okay? Because they come into the courtroom whenever there's court and make sure that she does her job right. Okay? They watch court and they make sure that she's doing what they tell her to do. And she does every single time. These judges were hired. That means they can be fired. Okay? She knows that. She does what she's told. She's a pushover, and she's got a son that's like 21 years old. And I hope he sees this video one day and finds out that his mom is racist, that his mom is being racist for other people. And really, she's just a pushover, you know, and that's sad because you're hurting children. You know, that's what she's doing every day. She's hurting kids for these people, and she loves her job. She does not flinch. She's not like sad at night or anything like that. She does not care about these kids. She's destroying families every single day in that courthouse. And people think she's not honorable at all. That's why she doesn't show her photo, because she knows what she's doing is wrong. She knows she's committing crimes every day. She can't use the Juvenile Court Act on anybody but juveniles. But she's been prosecuting parents for years. And she does not know what she's doing at all. She was never a prosecutor. So I don't know why they even wrote that on there. They write lies about everybody. You know, half these judges didn't do anything. Like any of the credentials that they say they have, they do not have. Okay, she's totally phony, fake, and she's the yes man. That's really what they are, the yes man. They agree to just say yes to everything. That's it. That's what she does. And she's the one that was that held a termination trial against me that I won basically, but then turned around and used that same case number that I had dismissed to take my kid again. That's what she did. That's how non-smart she is.